where he's going to be discussing all this again. Good morning, Barrister.
Good morning. It's my pleasure.
Lovely to have you here. You look wonderful.
Thank you very much for the compliment.
You're welcome. You're welcome. I just want to be particular in my compliments so that you know that I'm being intentional.
That's good.
Okay, Joshua, by the time we're done, you
No, I
understand
love
that she
corporates.
actually likes
Yes.
how you walked in. Now, talking about the new CJN, person of Kudirat Kekere Ekun, what legacy do you is looking at leaving, after her tenure?
Anyway, it has become customary for most retiring justices during validatory to highlight challenges that has bedeviled as an arm of government in Nigeria, one of which has to do with is encountered in the adjudication of cases. So, my Lord, the Honorable Acting Chief Justice of Nigeria can put in policies that will help see to read that cases, the challenges of undue delay of cases, which has bedeviled the Nigerian youth addressed. I think it will be a wonderful legacy. Beyond the quest for justice in the true sense of it in the Nigerian nation, even though what we call it, because jurisprudentially, what you may refer to as being reviewed by another person to be just, but that's not the issue for discussion.
Recording stop.
What I'm trying to say is that beyond the question of justice delivery, we should also know the issue of speedy adjudication of cases. You may be shocked to know that there are some cases pending at the Supreme Court, cases that were filed as late as 1985, 1980, that are still pending in court as I speak. Apart from cases that are time-bound, most especially election petitions, you discover that many conventional civil and criminal cases do suffer undue delays. And these delays that cases suffer are caused by multifaceted factors. So if my Lord can put in place, while exercising her powers, let me say his, because we don't refer to them as using the feminine description. If my Lord can exercise his powers as the Chief Justice of Nigeria to put in place proactive policies that will help ensure that at least there is improvement in the manner in which cases are handled in our courts, especially the appellate courts, it will be a very wonderful legacy. And we may not be quick to forget her.
You said you sparked some things. Now you said just for my audience, someone who is watching, who will say, is a she, you're calling he. How does you first, why do they reconcile? I could know that this is why, to just make it apart, but can you throw more light? One. Secondly, majorly, is how is it possible to swear in a Chief Justice of Nigeria without the approval of the National Assembly? How does that, is it legal? You are a lawyer, so is it legal to swear in the Chief Justice of Nigeria without the approval of the legislative arm?
Let me start with the second question asked. Presently, my Lord is acting, is the Chief Justice of Nigeria on acting capacity. So the law allows that because nature abhors vacuum. Following the retirement of the immediate past Chief Justice of the Federation, be my Lord, the Honorable Justice Ariwola, automatically there has to be an acting Chief Justice or a substantive Chief Justice. Now, the law is that for this appointment to be solidified or for it to be formalized, then the National Assembly, specifically the Nigerian Senate, has to give legislative approval to the appointment made by Mr. President. So for now, my Lord is operating on acting capacity basis, in which case it is lawful. The law allows that.
So if they eventually do not approve it, she remains in?
No. If the Senate fails to give approval,
yes,
then there are some other steps that will take in. For instance, the President will be called upon, to forward. They can, to the best of my knowledge, they cannot just reject the appointment without giving cogent reasons. But perchance, for some cogent reasons, they are unable to, ratify the appointment made. Then the National Judicial Council has to come forward with the names of other qualified persons. Of course, the President will be the one to forward those names. And then, from those names forwarded to National Judicial Council, then Mr. President will now decide the person to also send back to the Senate for approval. Notwithstanding, even if the Senate fails to give a stamp of approval to the appointment of the acting Chief Justice, the President can still send her name again back to the Senate for approval if there are reasons raised for the initial rejection of her candidacy. If that particular anomaly is rectified, if there is something that the Senate believes has not been done, or there's a deficiency, constitutional deficiency that is yet to be taken care of, for instance, and it is addressed, the President can rescind that name, just like what obtains in maybe in cases of appointments of ministerial nominees. If the Senate or the National Assembly says that, look, we cannot confirm the appointment which you have made in this regard based on so and so reason, if that if the issue raised is addressed, the President can rescind that name, and then the National Assembly will. All right,
Barrister. But what can be those reasons that could make the National Assembly say, okay, no, we can't go with this?
Anyway, there are a plethora of reasons. For instance, in the first instance, even before, ordinarily before one is made a Chief Justice of the Federation, the appointment has to be sanctioned by the National Judicial Council. And for that to be done, the person has to be deemed to be qualified to occupy that position. For instance, there is a particular number of years, because in as much as it is conventional for the Chief Justice of the Federation to be appointed from the 7 Justices of the Supreme Court, there is no law that also prohibits the President from even going outside the confines of the Justice of the Supreme Court to appoint a practicing lawyer. For instance, a practicing lawyer who has practiced law for at least up to 10 years in the country is also qualified to be a judge, in which case the President can go outside, the shores of the already existing Justice of the Supreme Court to appoint. So if, for instance, the person you are trying to put forward is not qualified constitutionally to occupy that particular position, then that would be a ground upon which the Senate will say no, that you have forwarded this person's name for us to give our stamp of approval, but we will not do that. Secondly, prima facie, the candidate may be qualified, but there may be an allegation, a very fundamental allegation against that person. Let's say allegation bordering on corruption. If prima facie the allegation is weighty, then the Senate may say that based on public policy, that you have the right to, to put forward the name or names of candidates, as the case may be, who you want to occupy this particular position, that this particular individual whose name you have forwarded to us, that there are fundamental challenges that has bedeviled his candidacy based on so and so reports. Let's say security reports. If there is a very, not just flimsy, there is a very cogent security report against the person sought to be made the Chief Justice of the Federation, based on that security report, the Senate can say, based on national interest, that we will not be given our approval, in as much as the President is given that powers to appoint whoever he wants to, subject to the fact that that appointment must be done in line with the Constitution. So it's not an open-ended power. And that's why the National Judicial Council is there to ensure that whoever may be put forward to occupy that position should be someone who is constitutionally qualified to occupy that position. Then, going by the first question you asked, just in a jiffy, we refer to them as my lord. Have you ever heard my lady? They just so a woman conventionally cannot be a lord.
But the symbol of law is a woman with a sword.
That's Themis, goddess of justice.
Yes, she's a
feminine. Yes, for the purpose of describing the role being played by judges. But in the true sense of it, in the days of yore, this is our judicial system basically is a colonial heritage. In the days of yore, ordinarily women are not even allowed to study law in the days of yore. Oh. Basically, is for the nobles, sons of women are not allowed rather to become judges in the days of yore. In the days where patriarchy held sway, basically they are referred to as my lord because women not ordinarily be expected to assume the position of lord, but that's what was the case in the days of yore.
Okay, so well, like you said, in the days of yore. Okay, so moving forward, I asked the other constitutional lawyer, Omanami, I asked him the fact that, okay, let me start by saying, why is the president the one to nominate or pick the person that becomes the CJN? Is it right in the right sense of it? Recall that Olisa Bakoba, a senior advocate of Nigeria, very notable person in the law firm in Nigeria. He said that the court in Nigeria presently works on the 844 model of the English court. So trying to marry it and put a balance to this, how do you reconcile it? Is it right for the president to be the one to nominate the Chief Justice of Nigeria?
It's not a question of whether it's right or not. You have to be talking about what obtains in our constitution. If a vast majority of us believe that it's not right for the president to nominate, then we have to call for constitutional amendment. But as it stands today in Nigeria, if you come to a state, it's the governor of a state who nominates. However, the constitution theoretically has put in place checks and balances. That's why I have the National Judicial Council. For instance, even in case of appointment into the office of a judge of a state, you have the Service Commission. And some of these institutions are there to ensure that in as much as the president is given the powers, for instance, in case of federal judges, to nominate, that it is those who are qualified to occupy that position that will be nominated. In other words, the president cannot just wake up and say, I hereby nominate Kekere or Okafor to become a judge, a justice of the Supreme Court or Court of Appeal. No, there are bodies already put in place to ensure that those individuals that they met the requirements of the law in terms of qualification, in terms of integrity. And that's why whenever the president is to nominate a federal judge or maybe a federal judge, the president directly or indirectly is to nominate a federal judge, members of the public are even called upon, to make any report about the personality of the individual sought to be appointed to that particular office. In which case, if there's any fundamental allegation against that person, it will be a ground upon which some of these institutions, like the National Judicial Council, will now say, we have a weighty allegation. It must be weighty. It shouldn't just be a flimsy allegation. Otherwise, we may end up not having judges. If there's need for appointment into a vacant office, one can easily put up a flimsy allegation. But if there is any prima facie strong allegation against a candidate, it will be a ground upon which these institutions will say, no, this person is not qualified to be a judge. So it has to do with our constitution. Just like in the United States, judges are elected. The way we elect political office holders here, that's how they elect judges in the United States.
By their president.
No, not by the.
That's what I'm saying.
By the electorate.
That's what I'm saying. The electorate.
So do you want the electorate to start electing our judges here for us? And it's left for Nigerians who are listening to answer. But I think...
I actually thought it's people in the judicial realm, or spheres of life, that are supposed to elect who they see deem for that position. Because they alone understand the weightiness of what he carries. Because just like right now we have the Minister of Petroleum is now the president. So that once upon a time, it will arise that the Chief Justice of Nigeria is also the president.
No, the point here is that you should appreciate the fact that even in the course of appointed, the members of the bar, lawyers practicing and that's lawyers, members of the bar, also play a vital role. The names of these candidates are forwarded to the bar for scrutiny, at least in theory, but it does happen. And that's when people are given the opportunity, lawyers are also given the opportunity to make comments. And from the information that I've gathered...
That's where or that's when?
I mean, before a judge is to be appointed, the name of the prospective judge will be forwarded to the Nigerian Bar Association for scrutiny.
Okay.
And that's when lawyers are given the opportunity to make their reports or remarks about that particular candidate. And there's any way, because we know ourselves, if as a lawyer, for instance, Mr. Kekere is about appointed as a judge, and I know that Mr. Kekere has very notorious reputation as a judge, I'm giving that moral authority, that moral and legal authority to say no, that this person is not qualified to occupy this position because of so and so reasons. That in time past, I've been opportune to transact with this particular lawyer. We've been able to, I've been opportune to handle so and so cases. And even in terms of competence, even before you be a judge, you are also expected to put forward the cases you have handled as a lawyer, at least for a period of, I think, presently, 5 years before the date of your indicating interest in occupying that position. This will also help the relevant agencies to appreciate whether you are conversant with the realities of the moment as far as law practice or the legal profession is concerned. Because they wouldn't like a situation whereby a candidate who has not been, in active practice, be it as an advocate or as a corporate lawyer, to just ascend that particular position. So they want to be sure that you are in tune with the realities of the moment. So if there's any challenge with our judicial system, as has been raised by the learned counsel, Mr. Abakoba, I think the best way to address it will be to amend the relevant provisions of our laws. Just like presently today, we still make use of our conventional wig and gown. In some other countries of the world, they are about doing away with this particular way of life. Whereas many of us, because of our strict adherence to the colonial heritage, are yet to come to terms with the fact that there may be nothing wrong with doing away with putting on wig and gown. So these are some of the issues we have to address by embarking on an amendment of the various laws that regulate the manner in which the legal profession is practiced in Nigeria.
All right, Barrister, thank you for such insightful insight. Now, let's go back to Kekere and let's talk about the judiciary system. What do you think are the key challenges facing the judiciary in Nigeria today? And how do you think she might be able to tackle these challenges?
I think if you ask an average Nigerian will raise questions about justice delivery. The issue of justice is a very controversial issue. The man you refer to as a terrorist may be viewed as a freedom fighter by his kinsman. So jurisprudentially, I wouldn't delve into the issue of justice this morning, because if I should do that without sounding any modest, 2 hours or 3 hours may not be enough for me to appraise the issues bordering on justice. But an average Nigerian believes that, or let's say many Nigerians no longer have faith in the judicial system. And I won't even stay here this morning to defend the judiciary, because there are many controversial outings of the judiciary as an arm of government. Many of us have not forgotten the remarks made by Senator Bukachua, which impliedly was an admittance on his part that cases are being influenced. Notwithstanding, I wouldn't like to make a general indictment of the judiciary as an arm of government, because even as I speak, I'm also a beneficiary of the benevolence of judiciary. Some months ago in this state, a particular judge of this state gave a ruling that went in my favor against a powerful establishment. So if all judges were to be corrupt, I don't think that judgment would have gone in my favor, because I won't mention the name of that, but this is an establishment owned by very powerful individuals in this country. But the judge looked at the facts of the case and ruled in my favor. Even as I speak, I've also had some judgments that went against me, some judgments which I would refer to as strange judgments. What am I trying to say? Basically, many Nigerians look forward to having a more sanitized judicial system that maybe we meet the yearnings and aspirations of rational thinking members of the society. But we should appreciate one thing. My Lord, the Honorable Acting Chief Justice of the Federation, has only one vote as a Justice of the Supreme Court. Admittedly, he wields enormous administrative powers, but he cannot, because he's the Chief Justice, Acting Chief Justice, or the Chief Justice, as the case may be, dictate for his brother Justice of the Supreme Court how to go about his case. So if a bench of the Supreme Court is constituted, let's say a bench of seven-member panel of the Supreme Court is constituted, it is the judgment delivered by the majority of these justices that will need to be the judgment of the day, irrespective of the position occupied by the Chief Justice. So the issue of justice is a different ballgame altogether on its own, because jurisprudentially, many factors come to play. At times, even when we lawyers, when we make mistakes in our cases, the judiciary tend to take the blame, just like what happened in the last presidential election. Let me say something without any apology. I have, for instance, read the judgment by the Supreme Court of Nigeria in this election petition. I have read that judgment. Irrespective of if anything may have happened, I don't know. But I can tell you that that judgment is a near perfect judgment. The only problem I have with that judgment has to do with the stance of my laws on issue bordering on electronic transfer of votes. I totally disagree with them. But apart from that facet of that judgment, believe you me, that judgment is in order. If you're talking about law, I'm not talking about those who are not conversant with the provisions of the law, because that particular judgment generated serious controversy. So if anything may have happened behind the scene, I don't know. But if you're talking about justice vis-a-vis the law, any lawyer who is not emotional, any lawyer who is conversant with the provisions of the law as far as the election petition is concerned, previous decisions delivered by our courts on the election petition, we will not have any challenge in coming to terms with the fact that that judgment is a near perfect judgment, save for the stance of the Supreme Court and Court of Appeal on electronic transmission or transfer of votes. And finally, at this juncture, I think many Nigerians are also in need of speedy adjudication of cases, because in as much as you're also raising issues on speedy adjudication of cases, many of us Nigerians are also complicit. If you are talking about delays in cases, many factors are responsible, basically 4 factors. Now, if you want to appreciate some of the factors that give rise to delays in our cases, just go and watch a football match. The judge is like a referee. Then litigants are like the 2 opposing teams. Have you that whenever a football team is winning in a match, towards the end of the game, they tend to embark on delay tactics? That's what happens in cases. When you have a bad case as a lawyer, many lawyers tend to intentionally delay the case. When you have a bad case as a litigant, many, like you're a tenant, you occupy the premises of a landlord, you're having issues with your landlord takes you to court. You will intentionally be embarking on delay tactics in order to frustrate your landlord. Your landlord will now be crying that judiciary is not doing well. That is when the judge, being the referee, is now expected to put in place some proactive measures that will help see to read that the person who is embarking on the delay tactics is penalized, and that case makes progress. Because ordinarily, if you leave some of us who are lawyers, we keep embarking on some delay tactics to frustrate cases, and at the end of the day, we come out and say, judiciary, we normally waste time in entertaining cases. So lawyers are complicit, litigants are complicit. Again, lack of modern day facilities. It's unfortunate that even today in Nigeria, many judges don't make use of stenographers. They don't have research assistants. They don't have well-equipped libraries. These are basic policies and facilities that should be put in place that will help guarantee speedy adjudication of cases. So we are still backward in terms of infrastructure and manpower. Then delays coming from litigants, delays coming from lawyers, and at times delays coming from judges. Even though I can tell you that many judges are not usually culpable in this regard. They may be culpable when they are not too firm in order to call to order the shenanigans of some lawyers and litigants. And interestingly, at times, when a judge wants a line of action, you may now find the lawyer, even the litigant, accusing the judge of maybe having interest in the matter. It's like, my lord has interest in this matter. Why is he doing so? These are the things we see. That's why the position of a judge is a very sensitive position. Because no matter what you do as a judge, you can never please the entire society. What is fundamental, just in a nutshell, as a judge, is that if you want to do the right thing, that between you and God Almighty, who is the supreme judge, you should always endeavor to do the right thing. But there's no way you give a judgment that the entire society will be happy with you. That is the reality of life.
Thank you very much, Barrister. Because of time, this is the much we can take. Thank you for such insight on this, Barrister Chinonso. Chukwunonso, thank you very much.
I appreciate it.
What's the difference?
It's a word of difference between Chinonso and Chukwunonso. Chukwu basically means God, whereas Chi may mean God or destiny or fate, based on the context. And again, I wouldn't like a situation where tomorrow they say that the certificate, yes, Chukwunonso, not Chinonso, and the matter will not end up in court. It's true. And they say judiciary has compromised the game.
Thank you very much. We'll be going on a very short break. When we come back, we have much more segments lined up for you. I'll see you after the break.